We're here for a pretrial and a bond violation. We're ready to resolve the bond violation. She will admit to the allegations of contact and would like to provide the court some context if you would allow that.
Go ahead.
Your Honor, I do admit I was wrong. Let me start there. I was wrong. When I got out, I thought that she was going to be at her mother's house. When we went to arraignment, they said she's going to be at her mother's house and I could return to my home. But I didn't know until the end, when they were releasing me, that I could not return to my home. So that was a surprise. And I called the police like I was told to do. She packed up some of my stuff. She left our marriage license on the front of my driver's side. I didn't know we were married, Your Honor, because we had gotten married a couple of weeks before and we had talked about not filing the marriage license. And so she filed the marriage license after the incident, and I did not know that we were married until she left it on the seat.
All right, folks, strap in. Today's courtroom moment wastes no time diving into high-stakes emotion. What began as a standard bond violation hearing quickly turned into something much deeper and far more personal. The defendant didn't storm in with bold claims or empty excuses. She stepped forward with trembling words and visible emotion. Instead of fighting the charges, she offered a raw and vulnerable confession that caught everyone off guard. She explained that going back home wasn't a calculated choice. It was a mistake made in a moment of confusion. According to her, she didn't even realize that returning to that address was restricted under her bond conditions. She said she felt forgotten, left out of the loop, like the system just moved on without making sure she fully understood the boundaries. Then came the emotional breaking point. She revealed a marriage license, an unexpected twist that shifted the courtroom energy entirely. And when she laid eyes on her son, that's when it all unraveled. The pressure, the guilt, the heartache, it all came pouring out.
When I did call, she had packed it up. She'd packed up my stuff. I did leave, but then I realized she didn't give me shoes. And so I called the police officers back. I was away from the house. I was down the street. I was trying to do the right thing. They got called, emergency, so I was waiting longer. And I saw my son get out of the car. And I saw her pull the trash cans up. I did not approach them. I did not try to approach them. But when I saw my son, that's what broke me, is I saw my son. And so I did violate, Your Honor, I did violate, but I was not aggressive. I did not approach them. I did not come near them. I did send text messages, but I didn't understand with the marriage license and it broke me. My son broke me. That's why. And I wanted to know if there was hope. That's all. And I do acknowledge I was wrong. I do learn, and I will not contact her again. 100%.
Let's be honest, this is the moment where everything spills out. The tension peaks, and emotions take center stage. She doesn't dodge responsibility. She stands there, voice shaking, and admits she made a mistake. Yes, she broke the no-contact order. Yes, she violated the terms of her release. But she makes one thing painfully clear. There was no violence, no threats, no confrontation. Just a few misunderstood messages and a heart that couldn't take the weight of separation. She says the confusion was real, but so was the pain seeing her child again shattered whatever composure she had left. It broke me, she whispered, voice barely holding together. She wasn't looking for sympathy, just a sliver of understanding and a shot at redemption. With tears in her eyes, she pleaded for one more chance, promising she'd never reach out to the victim again. No matter what. It was a raw, human moment, one that asked the court to weigh the letter of the law against the heartache of reality.
I will add, Your Honor, she has been in custody for about 5 days, I believe. If she were to be released, she would be staying at a hotel nearby. The house was recently flooded, so she actually has funds from the VA to stay somewhere else. There's work being done on the house. So given her admission and her owning up the fact that she did violate the court's orders, I'd ask that you sentence her to those 5 days.
What are we doing on the pretrial?
We're asking for an adjournment
Right.
on the pretrial.
Do people have something to say, Mr.?
Yes, Your Honor, we would object to that. Given the nature of these texts and the fact that they were sent, she was, I believe, arraigned on the 22nd, sent these immediately after getting out and being told not to have contact. And in those messages, she rightly acknowledges that she was not to be having contact, continuously telling the victim not to contact police, and then sending other manipulative messages to the victim, intending to make her feel bad for contacting the police or trying to contact police.
But don't get it twisted. This isn't just a tearful apology on repeat. Her defense attorney steps up, steady and confident, ready to shift the narrative. He lays out the facts. She's already spent 5 days behind bars. The home she once knew is now water damaged and unlivable. And the VA had even arranged a temporary hotel stay as part of a support plan. They are not asking for sympathy, they are asking for fairness. Time served, and a chance to reset. But the prosecution? They are not budging. They counter hard, and their message is crystal clear. This wasn't just a misunderstanding, it was manipulation. They point to text messages they say reveal attempts to sway the victim, to keep them quiet. This wasn't just about breaking a rule, it was about bending the situation to her will. And just like that, the courtroom flips from emotional plea to serious allegation. The prosecution paints a picture not of a woman broken by emotion, but one using emotion to cover a calculated move. And suddenly, this case isn't just complicated, it's explosive.
When's my next day?
May 13th.
May 13th.
Yes.
I'll adjourn the pretrial in this matter to May 13th. At that time, I'll also sentence her on the bond violations on that May 13th, and then her bond at this time, given what I've seen here, her bond will continue as revoked. Can
Yes, Your Honor.
Thank you.
Teresa Clare on behalf of probation. Your Honor, Mr. Anderson is before the court for a violation of probation hearing. Mr. Anderson violated his GPS tether that he had on. He entered into the exclusion zone, including going to the victim's residence, and also took her vehicle. They then tracked the GPS where he removed the tether and left it in Flint. Mr. Anderson failed to enroll in the domestic violence program, and he failed to continue to report as he should. I would also like it known to the court when Mr. Anderson walked in and up to the podium, he was looking, trying to make direct eye contact with the victim who was present.
Hold up. Just when you think things couldn't get any messier, the next wave of courtroom drama crashes in. Enter Mr. Anderson, and with him comes an entirely new layer of trouble. This time, the violation isn't minor. It's serious and stacked with red flags. He didn't just miss a check-in. He allegedly removed his GPS monitor, entered off-limits areas, and even took the victim's vehicle, but it doesn't stop there. According to probation officials, he's been completely unresponsive. He disappeared from his domestic violence intervention program without notice, ignored all mandatory reporting, and showed zero effort to comply with the terms of his release. And in a bold move, he even made direct eye contact with the victim inside the courtroom, raising immediate safety concerns. Probation is done giving chances. They aren't recommending counseling or community service. They are asking for jail time. A full 93 days. Behind bars. To them, he's not just a rule breaker, he's a risk, and one that needs to be removed from the streets immediately.
Your Honor, given the violations of Mr. Anderson and his clear non-compliance with what this court ordered, probation is asking that the court sentence him to 93 days in jail, credit for 33 days that he served to date, to serve the balance, waive remaining terms of his probation, accept his financial obligations, and discharge him from probation without improvement.
Ms. Coons.
Your Honor, My client would like to admit to the violations with explanation. I think that he is very apologetic about his actions. He just lost his sister and he's grieving right now. He's not in the right state of mind, and he understands that he has made some poor decisions here. As to the no contact violation, he had news that the complaining witness was possibly selling his stuff. He does understand that the proper remedy would have been to go through civil court after discussion with him. And particularly to the vehicle was in both their names, but again, I did discuss the civil court with him. As to the lack of payment, it's due to a lack of monetary funds. His sole source of income is from Social Security. He's been homeless since the beginning of this case and just fell on a hard patch in life. And that goes for the domestic violence program as well as to why he didn't complete that. In addition, he did not have transportation. So, Your Honor, we would leave it inside the discretion of this court as to the recommendation, but we would ask for some type of leeway on account of him just not being in the right mind state. He's grieving and he just lost his sister.
Now comes the turn, tears, a twist, and an apology wrapped in layers of explanation. Mr. Anderson's attorney steps forward, hoping to ease the tension and offer some human context behind the violations. The man's life, the lawyer explains, is unraveling. His sister just passed away. He's grieving, homeless, broke, and without transportation. He wasn't skipping classes out of defiance. He simply had no way to get there. And about that GPS violation? Mr. Anderson believed the victim was selling his personal belongings while he was gone. In his mind, that justified confronting the situation. Though clearly, the court sees it very differently. Even with these struggles, the defense concedes. He went too far. He made poor choices. But the bottom line? Rules were clearly set, and he broke them. The court didn't leave room for confusion. It issued warnings, laid out expectations, and gave chances. Mr. Anderson didn't follow through. And now those earlier decisions are catching up to him. The excuses may explain part of the story, but they don't erase the consequences. Now, it's all on the table.
Your Honor, I just would also like to make it known to the court. I had a meeting with Mr. Anderson. It was made extremely clear where he could and could not go. So it wasn't a stuff been made about the truck, as he indicated that it was in both of their names. He was told what he needed to provide to this court if that he wanted to pursue that. Just taking it upon himself and leaving his daughter's home where he was staying in Detroit and coming here and going to her home and taking a vehicle was against what he was instructed to do. He knew full well that he should not have been in the exclusion zone, period.
Anything you want to say, sir?
I came down here when I seen her, and I have friends here that I've been, and I understand that when I talked to you, you made it clear to me 5 miles. I understand that. But she told me that the police don't have time to be running over there to see about my things, and that I shouldn't come.
She who?
The lady that was just talking.
Ms. Polera?
Yeah. And then you said not to even come to Washtenaw County at all. And I'm like, you know, she wrote it on this paper. So, Your Honor, I'm just...
Well, why'd you take the GPS tether off then?
I was going through some things. I lost everything. I was wrong.
Oh, I know.
And I understand. I mean, I was going through some things, Your Honor, with this whole situation.
Court will
accept the admissions to the violation. Court will follow the recommendation of probation. They will waive remaining terms, accept his financial obligations, discharge him from probation without improvement. Sentence you to 93 days, Washington County Jail. Credit 33 served. Defendant is to serve the balance. I'm not even going to consider an early release. Thank you.
Thank you, Your Honor.
All right, sir.
This was it, the final gavel drop. No more chances, no more excuses. Mr. Anderson stood before the court, voice cracking, words stumbling out in desperation. He confessed to everything. He lost his home, his job, his stability. He was grieving, disoriented, and had nothing left. It was a heartfelt plea, full of emotion. But this time, the courtroom wasn't moved. The judge wasn't looking at a man in pain. The court saw a man who broke the rules that were clearly explained from the start. Tampering with his GPS tether wasn't just careless, it was intentional and dangerous. That move alone erased any chance of leniency. The sentence came down hard, 93 days in jail, with only 33 days credited. No early release, no softened terms, just a clear message that accountability still matters, because in this courtroom, poor choices come with real consequences. And when trust is broken, the verdict is final.